So thank you everyone for joining us today. I'm Anisa Abeytia, and I am a graduate student in the Department of Migration Studies at the University of San Francisco, and also the think tank program coordinator for the Global Research Network. Today, I'm joined by Dr. Jasmine Tuitt, who is the Assistant Director for the Institute of Migration Studies and Professor of Migration Studies at the Lebanese American University at the Department of Social Sciences, and remotely by submitted video, we will be joined by Dr. Sara Dehn. She is a senior lecturer at the Faculty of Law at the University of Technology, Sydney. And we're also joined by Patricia Tuitt, formerly professor and dean of the School of Law at Brickbeck University of London, and Professor Bill Hing, who is a professor of law, migration studies, and an emeritus Asian American Studies professor at UC Davis and part of the University of San Francisco. He's a professor of law, migration studies. Unfortunately, Dr. Anisa Abeytia is not going to be able to join us today due to an emergency. Just want to give a brief background of how this panel came about. By various discussions that I've had with many of the panelists, thinking about how immigration and asylum law isn't reflecting the reality and needs of asylum seekers coming particularly from the global south. And these multiple refugee crises that we're periodically faced with, and as countries in the global north continue to say that they're taken by surprise by these large influx of refugees and asylum seekers and economic migrants, as they're called. But they overlook the numerous root causes and the policy failures on the part of not only the international community, but also various individual nation states. And so today we're going to focus on kind of some of the root causes as well as the dysfunction of asylum and immigration law from different perspectives. So we have the United States, the UK, the Middle East, and Australia represented today. And with that, I'll go ahead and ask my first question. So despite location, whether it's in Canada or in the UK, the United States, or the Middle East, asylum law in the global north are functioning more as a way of preventing the movement of asylum seekers from the global south, which highlights this inability of national or international organizations and states to provide an organized means for movement. Could you provide an overview of your country's approach to asylum from about 2009 till today, and the changes to the laws and policies you've witnessed that have created barriers to asylum and move asylum law away from more focusing and being concerned with human rights? We're going to begin with Dr. Dehn.
Hi, thank you so much. Can everybody hear me okay?
Yes.
Great. Lebanon is always an interesting case study when we discuss asylum because Lebanon publicly does not declare itself a country of asylum, but rather a country of transit. In application, this has meant that two of the largest refugee populations in the region that are housed in the country at the moment, whether this is the Palestinian Syrians or the Palestinians or the Syrian refugees, all kind of exist in this legal gray zone, in this legal limbo when it comes to asylum. Lebanon is not signatory to the 1951 Refugee Convention, nor the 1967 Protocol, and currently upholds kind of an ad hoc and reactionary approach when it comes to refugees and asylum in general. Different laws, different policies, different directives are kind of negotiated and applied based on different political climates, based on different instances in the country's history. For the last decade, Lebanon has been at the center of the Syrian crisis. Currently, more than 1 million refugees from Syria reside in the country. with, of course, disputes on numbers of how many Palestinians are in the country. Different sources place them between 250,000 to 400,000 as well. And in light of the fact that Lebanon to this day does not have a unified and stable policy towards the refugee community and an understanding of asylum, this has translated into the country's political history as well. I can dive into more details if you'd like during the Q&A, but to sum up the country's political history with the Palestinian refugees largely informed their response to the Syrian refugee community. And these two experiences continue to pose challenges when it comes to Lebanon's understanding of asylum law, its application, and whether or not Lebanon would consider itself a country of asylum in the future. At the moment, the country does the bare minimum. It adopts the non-refoulement principle, but really stops there. So that's a little bit on Lebanon for everybody. Thank you.
Thank you. First of all, thanks for giving me the opportunity to participate. I have had a cold. I hope I can be heard, and I hope my voice does hold out. This particular period in international refugee law is often talked about as a period of international or cooperative deterrence. And I think that's significant in the sense that certainly in terms of the global north, many of the policies are very similar. Often these very restrictive policies have been initiated by Australia, and then in a few years' time, other countries have taken them on. And so I think that context is important in terms of thinking about the UK. The other aspect to think about in the context of the UK, of course, the UK is no longer part of the European Union, but has been a significant player in the European Union during the period in which the Union developed most of its recent deterrent strategy. So I certainly don't think we can, that the UK can insulate itself from the policies that are happening in the European Union. And I think it's generally accepted that the EU, along with Australia and the US, are at the forefront of some of these very direct and quite brutal policies of essentially containment of refugees. And I think I'll talk more about some of that detail in relation to the next question. But just to highlight a couple of aspects of UK policy that I'm not sure, maybe there may be greater emphasis perhaps in the UK compared to other states, and that is the application of the internal flight alternative, or sometimes talked about as the internal protection alternative, which, as we know, is used to deny refugees refugee status to persons whose risk of persecution is present in only a part of the country. And this is, of course, a strategy that began to emerge in the 1990s, but is really now, and it was relatively limited use at the time, but I think it's quite a major prong of UK policy. Now, this inevitably places an enormous, and many would say legally unreasonable burden on refugees, essentially to prove that, in essence, the entire area of their country of origin or domicile is unsafe in the context of their protection needs. And the policy, at least as far as it's applied in the UK, appears to operate without any, or at least any adequate consideration of whether the individual has any family or other ties in the place that is deemed to be an internal flight alternative. What might be particular to the UK is that the policy suffers also for really very flawed information relating to the countries of origin, and more generally, the Home Office have been fairly publicly criticised for the quality of decision making, not just in relation to asylum seekers. Of course, I think the most well-known example was in relation to the Windrush case, but we have also a question of the actual quality of decision making and the quality of knowledge about the countries that refugees are being returned to. I don't want to take up too much time, but just a couple of other deterrent measures that are part of the UK regime. I think there's increasing use of the Article 1F exclusion clause. And this is particular as the language that is explicitly connecting refugees with threats posed by international terrorism has really begun to take hold. So that is that. There's also signs that refugees are being penalized for illegal entry without any sufficient attention to Article 30, paragraph 1, which is the non-penalization. So yes, this is just a few examples of what's happening in the UK. But I think in terms of the almost entire denial of human rights in relation to refugees, I think the UK's role initially as part of the EU is where they have perhaps done as most damage, and I'll perhaps come back to that in the second part.
Thank you so much for that explanation of the UK asylum law. With that, we'll turn to Professor Bill Hing.
Thank you very much, Anisa, and thank you for organizing this, and I'm happy to join this illustrious panel. It's interesting that you chose as a kind of a starting point the year 2009, because at that time the United States wasn't quite facing the types of headlines that it has in the last 6-7 years with respect to migrants at the border, because in fact, up until 2009, the number of so-called undocumented immigrants that were trying to cross the US southern border had steadily declined over the years consistently. It was at an all-time low at that time. But it's interesting that a year before, in 2008, in the last year in office of President George Bush, he actually signed legislation dealing with the potential plight of unaccompanied minors in legislation that was labeled the Trafficking Victims Protection Act of 2008. So quietly, compared to the last 6-7 years, steady numbers of unaccompanied minors that were attempting to cross the US southern border. So already in 2009, 2010, we did begin seeing unaccompanied minors, not just from Mexico, but from the so-called Northern Triangle of Honduras, Guatemala, and El Salvador. And that was eye-opening for many policymakers and advocates who were paying attention, because most people were quite familiar with the 1980s and the fact that Central Americans were fleeing civil wars in the 1980s. Now there were new reasons why people might be fleeing the Central America and Mexico to come to the United States, in particular minors. Also, 2009 marked the end of so-called family detention centers in the United States under the George Bush era. George Bush had a family detention center that was infamous in a rural part of Texas. And by 2009, it was being closed down. And in fact, that's one of the very first things that President Obama did when he entered office in 2008, was to shutter a family detention center in a place called Hutto, H-U-T-T-O, Hutto, Texas. Things began to drastically change in the first term of President Obama, and near the end of it in 2012, 2013, we began to see rising numbers of unaccompanied minors fleeing from Central America. And the headlines, after he was reelected, he was reelected in spite of the fact that one of his big promises was a delivery of immigration reform. And he was heavily criticized by the left for not doing more. And then all of a sudden, this is kind of deja vu because it's happening to President Biden right now. But in the first few years of President Obama's second term, that's when this large number of unaccompanied minors began coming again, a surge, something along the lines of 60,000 unaccompanied minors approached and did actually enter the US southern border in 2014, an equal number in 2015, another 60,000 or so unaccompanied minors. What did not hit the headlines was that there was an equivalent number of family units, mostly women and children, also fleeing Central America and parts of Mexico. And the root causes of those large surges were largely violence, and it was different kinds of violence. It was gang violence, and it was cartel violence, and a lot of domestic violence. And so huge numbers began to challenge the Obama administration, and disappointingly, he responded by opening detention centers that had previously been closed. He opened his first family detention center in Artesia, New Mexico in 2014, and within a year he opened two more in Texas that still exist, and then another one in Pennsylvania a few years later. And instead of processing, and this kind of segues into the second question, instead of processing folks, allowing them to enter, allowing them to not be in detention, and orderly being told to show up at their removal proceedings in order to apply for asylum in different parts of the United States. And instead of doing that, he took them into custody largely. And by the time President Trump was elected in 2018, the family detention centers were operating. Now, President Trump took all of this to new levels and new heights, and the world is probably more aware of what President Trump did than President Obama. But it's, in essence, he tried to rewrite the rules. Mr. Trump tried to rewrite the rules for asylum seekers, although there was developing case law that certain people fleeing gang violence, certain people fleeing domestic violence, excuse me, could qualify for asylum. President Trump's attorney generals issued rules that tried to end the possibility for asylum protections for people fleeing domestic violence and gang violence. And on top of that, he threw all kinds of procedural rules at the border, including what was known as the Migrant Protection Protocol, often alluded to as the Remain in Mexico policy, which still exists, that requires asylum seekers to wait their turn in Mexico before they are allowed in to apply for asylum. And there were other rules that Trump had imposed, such as if you came through a third country before reaching the southern border, well, you had to apply for asylum in the third countries. So there was pressure placed on Mexico to at least allow Hondurans, Guatemalans, and El Salvadorans to apply for asylum in Mexico. And then there were several other things, but probably the big one near the end of the Trump administration is what's known as Title 42, which was a brainchild of Stephen Miller Trump's aide, who it's very clear that he has racist motivations throughout the period of President Trump's presidency. The Center for Disease Control, which has jurisdiction over Title 42, refused to implement Title 42. So Title 42 is a federal law that permits a very close scrutiny of people who are entering the United States who may have health problems. And there's a debate over the authority of Title 42, whether or not it permits expedited removal or if it just allows quarantine. And that's being litigated right now. But the long and short of it is the Trump administration used Title 42 as a pretext for excluding people beginning in March 2020, at the beginning of shelter in place in the United States vis-a-vis the pandemic. And over the objections of the CDC, over the objections of then Senator Kamala Harris, now Vice President, over the objections of Anthony Fauci, Title 42 was put in place to stop people from entering. And to the big disappointment of President Biden's supporters, he has continued to apply Title 42. And so since its inception in March 2020, some 1.3 million people, including legitimate asylum seekers, have been barred from entering the United States and applying for asylum. The only important exception is for unaccompanied minors. So let me stop there and let Anisa turn to some of the other speakers. Thank you.
Thank you. I'm going to go ahead.
Let me start by acknowledging that I speak from the unceded country of the Gadigal people of the Eora Nation and pay my respects to their elders past and present. I acknowledge that sovereignty of this land has never been ceded and the need to foreground the urgency of the fight for First Nations justice here today, as well as its connections to the struggles for migrant and refugee justice in Australia more generally. I also want to thank Anisa for organising this panel and for the kind invitation to join such a wonderful lineup of speakers and scholars whose work I admire and learn from. Given that, I'm very sorry to not be able to participate in the discussion in person, but hope my brief reflections on the situation in Australia are nonetheless useful for the discussion that will follow. Australia is in many respects both an extreme example of a state in the global north that has gone to brutal lengths to deny refugees access to asylum, but serves also as an example of the manifestation of some longer transnational trends that seek not only to deter refugees from seeking asylum, but also make it near impossible for asylum seekers from certain states or regions to arrive safely in Australia at all, through, for example, practice such as militarised refugee boat turnbacks and the use of punitive and prolonged immigration detention in neighbouring third states. Although Australia is a settler colonial state like the US and Canada, has a long history of racial exclusion, most notably through the racist White Australia policy that existed for large portions of the 20th century. There have been some very notable and deeply draconian shifts in refugee law and policy over the last couple of decades that have seen a resurgence and transformation of such exclusionary border practices. So in my brief remarks today, I want to name 4 key legal measures or barriers that have functioned to deny people access to asylum in any meaningful way in Australia in recent years, despite Australia's ratification of the Refugee Convention and despite the Convention's obligation not to impose penalties on refugees who enter a state without authorisation, provided that, and I quote, they present themselves without delay to the authorities and show good cause for their illegal entry or presence. So the first of these punitive policies really is or was the introduction of mandatory immigration detention in 1992 for any asylum seeker who arrives in Australia unauthorised, that is without a valid visa, by boat. This law was subsequently confirmed as allowing for the indefinite detention of refugees, including stateless refugees who have no real ability to leave Australia. Unlike in the UK, for instance, Australia does not have a system of immigration bail, but rather a person's release from immigration detention is entirely at the discretion of the Immigration Minister. And in fact, Australia's Migration Act actually seeks to prevent the courts from exercising any power to release a person from immigration detention. In reality, this means that the average period of time a non-citizen spends in Australian immigration detention is now over 600 days, or close to 2 years. Added to this, we saw a real articulation of a logic of disposability or failure to value refugee lives and the lives of other non-citizens in immigration detention as lives worthy of protection during the current COVID-19 pandemic, where the government for a long time and indeed continues to actively refuse to release refugees from closed immigration detention, despite expert health advice, the well-documented risks of infection that this creates, and sustained public protest. The second noteworthy barrier to asylum in Australia's law and policy is that of offshore detention, introduced first in 2001 and operationalised again from 2012 onwards till the present. So since 2012, Australia has sent over 5,000 refugees and asylum seekers to be detained on neighbouring Pacific Island states of Papua New Guinea and Nauru, both states with a shared history of Australian colonisation. Many of these transferred people have since been officially recognised as refugees, and yet they have been forced to endure up to 8 or more years in a mixture of unhygienic, overcrowded tents, closed immigration detention, or temporary supported accommodation. In addition, since 2012, around 9,500 people have returned to their states of origin from Australian offshore detention, amounting to a kind of self-deportation arising from conditions that push refugees to points of hopelessness. Of course, the legitimacy and viability of Australia's offshore detention regime has come under sustained protest and resistance from refugees and asylum seekers incarcerated there, as well as Australian civil society organisations. This occurred most visibly in 2017, when refugees on Manus Island were engaged in a brutal and protracted 3-week standoff with PNG authorities after refusing to be transferred to different temporary accommodation. This standoff led the UNHCR to declare Australia's policy and practice of offshore detention as having created a looming humanitarian emergency and an unprecedented mental health crisis. While hundreds of people have since been transferred to Australia from offshore detention for medical reasons, or indeed have been formally resettled in the US or Canada, the refugees who remain on PNG and Nauru, as well as the refugees who are now in Australia on temporary short-term visas, continue to have drastically inadequate access to healthcare while enduring legal limbo, precarity and insecurity. Internationally renowned Kurdish journalist and writer Behrouz Boochani has described the experience of Australian indefinite offshore detention as soul-destroying. He writes, and I quote, "The prison maintains its power over time, the power to keep people in line. Fenced enclosures dominate and can pacify even the most violent person. Those imprisoned on Manus are themselves sacrificial subjects of violence. We're a bunch of ordinary humans locked up simply for seeking refuge." End quote. Third, I think it's worth noting that the violence of Australia's border regime extends to actually legally denying certain refugees and asylum seekers the legal ability to apply for asylum. Indeed, Australian migration law creates an arbitrary distinction between asylum seekers and refugees based on their mode of arrival in Australia. Asylum seekers who arrive by plane and receive immigration clearance are able to apply for permanent protection visas. In contrast, asylum seekers who arrive in Australia by boat without valid visas are classified as unauthorised maritime arrivals, UMAs, and are statutorily prohibited from applying for any substantive visa, including a protection visa. The only way that a person classified as an unauthorised maritime arrival can legally apply for asylum in Australia is if the Immigration Minister exercises a personal, non-compellable public interest power to allow them to do so. In addition, since late 2014, asylum seekers who arrive by boat are only able to apply for temporary protection in the form of either a 3 or a 5-year visa. This reintroduction of temporary protection for a distinct class of refugees only has significant implications for their ability to enjoy asylum in Australia, resigning them to a cycle of insecurity, precarity, uncertainty, and also potential exploitation. And also puts them at risk of future refoulement with each visa expiry and reapplication process. The UNHCR has vocally criticised this differential treatment and reiterated that temporary protection is only ever appropriate in exceptional circumstances, such as situations of humanitarian crisis, and only until proper status determination processes can be instituted. Finally, in terms of additional barriers to asylum, successive Australian governments in recent decades have created situations of abandonment for refugees living in the community through, for example, the withdrawal of social security or even legal aid support for their asylum applications. This abandonment was further heightened during the COVID-19 pandemic, with the Australian government's refusal to include refugees on temporary visas in their pandemic financial support package provided to citizens and permanent residents. This situation of produced destitution for asylum seekers and refugees on certain visas is the extension, I think, of long-standing attempts by successive Australian governments to try to demonise refugees who arrive unauthorised by boat in Australia as, and I quote, queue jumpers or economic migrants who paradoxically both steal jobs and add to increased unemployment or cost of living pressures in Australia, according to government rhetoric. This, of course, is not the case, but nonetheless, there has been a real concerted attempt on the part of successive Australian governments to manufacture racism towards refugees and increased xenophobia for some sort of perceived electoral gain, which has created additional barriers, I think, to people's ability to feel safe and accepted in the process of seeking asylum in Australia. So to sum up, in Australia, I think it's not so much that there's a gap between law on the books and reality on the ground, but rather Australian domestic law has become an active and key instrument in denying certain refugees access to asylum, in furthering practices of refugee exclusion, and in instituting settler colonial violence towards certain racialised non-citizens.
Well, it was very sobering view of the immigration and asylum situation in Australia. But as you see, even within just the discussions of the panel, there's an overlap of this criminalization of asylum and immigration to the global north. And we spent this first part of the panel looking at what the problems are, within the law is causing this dysfunction. So in the second part, I'd like to focus more on what can work, where does hope or solutions lie in approaching what has become a kind of a crescendo of asylum seekers to the north. So first, I'd like to ask each of you, within the context of your research, the country that you work and reside in, where do you see the hope and in the form of policy and legal perspectives, and where do you see solutions? And secondly, do you think an approach to asylum law that embraces the spirit of human rights can offer up recommendations that work both for asylum seekers, nations, and also for supranational governments like the EU? So first, I'll turn to Professor Hing, who will start us off.
Thank you, Anisa.
If you need to repeat the question, because I know there's two, please feel free to do that.
Yeah, sure. I'm happy to address the question from the United States perspective of what is possible and what might give us hope. And as everybody knows, and this is true at probably any place of the world, what may or may not happen in the United States is unfortunately often a political calculation. And it's tragic that the people that are caught in the middle of these political calculations are folks that are fleeing persecution. The problem, one of the basic problems, if you just looked at it from a legal perspective, is that the U.S. immigration and asylum case law does not allow one to fit into the framework a typical story of someone fleeing the violence of a country such as Honduras or Guatemala. That oftentimes individuals are caught in the middle, and they don't have the kind of specific evidence that's necessary to make out a very fine immigration asylum claim, even though I would debate that, but that's a perspective that the decision makers make. And so I do think that the answer is a political answer, but also a practical one. I think that pressure must be placed on the decision makers to extend what is in the United States called temporary protected status. There is a statutory provision that allows the president very powerfully to make decisions that affect hundreds of thousands of individuals that make their way to within the United States borders, and for reasons that range all the way from violence, but to also natural catastrophe. It's kind of the only provision in the law that has any climate-related possibilities that the president can actually grant temporary protected status. And over the years, dozens of countries have been, nationals from dozens of countries have been granted temporary protected status in the United States, from the Sudan to Honduras to Haiti, but those have to be renewed. And I think that the president should do that and explain the circumstances. That's for people that have made it here. Those at the border, generally speaking, temporary protected status is not extended to people who are not within the United States territory. And in that regard, again, the administration has authority. The administration has begun to demonstrate a little bit of this with respect to people fleeing Afghanistan. The administration has the authority to extend something called humanitarian parole to individuals who, for various reasons, need to be protected and have approached the United States for protection. And so what I would advocate for is a generous exercise of presidential authority to do those two things: a broad temporary protected status order for those who are here, and a broad and generous opening of the borders with respect to humanitarian parole for individuals that are at least at our southern border, if not beyond, and to set the example that that the United States is capable of doing. Thank you.
Thank you for the very insightful suggestions and recommendations. We'll move to Patricia.
Thank you.
Would you like me to repeat the question at all?
No, that's fine. I think I probably will focus more on the second half of the question about the human rights paradigm. I mean, so I'm going to answer the question perhaps not very specifically in relation to the UK. I mean, in general, though, I would say I don't feel that hopeful. And really, it's because I think what we're seeing is a certain level of, quite frankly, lawlessness. And I think when the law, and in this context, it's the law relating to refugee status, obviously, that we're talking about, is if there's a sense in relation to particularly northern states that those obligations should not be borne by them anymore, and the focus is on addressing the refugee situation on the basis of preventing refugees from meeting the precondition of asylum, which is that they must be outside their country of origin. I think when we get to a situation like that, it's quite difficult to be hopeful. So let me say something though about the human rights. There's no doubt that human rights principles have proved to be, in the past, invaluable aids in interpreting key aspects of the convention. I mean, it is the case, for example, that the principle of non-refoulement is much more entrenched under human rights than it is indeed under the convention, because under the convention, for example, it doesn't apply, or effectively doesn't apply to 1F asylum seekers, whereas it has been established that even in relation to those refugees that are deemed to be undesirable in terms of security or other concerns, that under human rights law, they cannot still be returned to a country where they may face persecution. And of course, the human rights has probably its greatest achievement has been in extending the range of people who can fall within the definition of refugee. And I think there's still opportunities for stretching the convention. But nevertheless, despite these advances and these opportunities, I think it's always been the case that certain critics of the human rights paradigm, and I have always been one of them, have long warned of its capacity to do violence to the refugee cause, and not least by seeking to go beyond its original purpose, which was really just to provide an evolutionary approach to the interpretation of the Refugee Convention, where I think it has done well, but I think we've gone well beyond that in terms of human rights. Just as a note, I think one recently published book that I think is relevant in this case is by Robert Bandari. It's published by Routledge, in which the author unapologetically attributes the human rights turn in refugee law scholarship and practice to what is these practices of international deterrence, that it's that containing refugees in their countries of origin is in essence facilitated by human rights discourse. And I think it's notable in this regard that in the last 20 years, during which the human rights paradigm has been most dominant, the number of refugees residing in states within the developing world has apparently rose from what would have been around 70% to something like 84%. So to put it at its mildest, I think that the violence of the human rights paradigm is beginning to far outweigh its emancipatory potential. So, I mean, just to give just a couple of examples, as we don't have a lot of time here, just efforts, for example, to combat human trafficking and human smuggling, and obviously this is an important concern. But some of the measures that are employed to do so apply to refugees who, as a result of these policies, do not have safe and regular pathways towards international protection. So states of origin are under pressure to control the irregular movement of their own nationals, which does have an impact on the border. And the patrolling of sea borders, for example, and the interception of refugees, and often, towbacks to their country of origin, are again justified on perfectly laudable human rights grounds, which is the protection of, the prevention of deaths at sea. So I guess this is really just highlighting the fact that any discourse, however positive it may appear, can can be manipulated to the objectives of state. So in the question, do we need a new paradigm? That is what I think. I think the human rights paradigm has reached the limits of its efficacy. I think we need a new paradigm. This is a period when I think we're talking in many contexts, not just the refugee context, of a decolonial paradigm, a decolonial approach. And I think perhaps that is precisely the kind of approach that we need. And we have the seeds of a decolonial approach within the other regional conventions that have not had the same level of influence as the Refugee Convention. And I think that's perhaps where we need to be looking. Thanks.
Thank you for your response. And we have a question. If you could repeat the title and author of the book again. Oh, you're on mute. You can also type it into the chat box as well.
I'll put it in the chat box.
Okay,
Sorry. Yeah, let me.
We will go ahead and.
I'll pop it in the chat box in a minute. So.
I know Professor Hing has to leave in a few moments. Let me give you at least these last few minutes before you have to leave us. If you have any further comments for the panel.
Yeah, just to pick up on what Patricia just said, I agree. I think I agree that we need a new paradigm beyond the human rights paradigm. My hesitance is that I haven't given up on that paradigm, I guess, and but I have given up on related to that, and maybe you're saying the same thing. I have given up on world leaders using that paradigm and respecting it the way that I think you and I would. And so yeah, I mean, you've given that you're causing many of us, I think, to think, well, what should the paradigm be? And maybe I should toss that back to you. What are you thinking when you say we need a new paradigm? How would you? Are you thinking something much more pragmatic, something more formulaic?
Yes. Probably. So I'm trying to think of the best way to answer this in the time allotted. I think one of the most striking features of the current international, as in terms of the global north anyway, the approach, the deterrent approach, relates to the measures that mainly the EU, Australia, and to some extent, I think also the US, are taking to ensure that third parties, countries outside the global north, are effectively responsible for meeting obligations under the Refugee Convention. I mean, there's been a lot of legal debate about the extent to which international law will still render those countries liable. So the effort may in fact be, in terms of international law, may be ineffectual. There probably will be ways in terms of joint liability, complicity concepts and so on. But nevertheless, I think it's really important that the effort is to, in essence, not content with exporting a Eurocentric concept of refugee to the rest of the world. What northern states seem now to be doing is essentially saying that the only states that should have the legal burden of refugees are those southern states. So this is not this is not just a repetition of the old sort of colonial trope that that these are countries and peoples without laws who must receive those laws from the North. I don't think it's simply a mere repetition of that. I think it's an extension, because it's also saying we don't need law, and it's only those parties. So looking at those extremes, I think then my reaction is, again, that we need to go, that's why I said I think it is a decolonial paradigm, that the early promise of the OAU Convention, for example, or the Cartagena Declaration, for example, perhaps, and I'm not being naive and saying that simply by looking at that instrument that everything will be improved. But one of the things that I was struck by when I was reading some research recently, and I'm a refugee researcher, so I fall into the same trap, is that most of the analysis that's out there, the case law that is available, is all about the Refugee Convention. It's all interpretations of the Refugee Convention, not others. And this is partly because of cost of translation and the dominance of the English language and so on. But it does mean that there's very little to talk about in terms of other approaches so I think it's I guess it's that I'm looking at. I think perhaps I was too harsh with the human rights approach. Obviously it has made some achievements, but I do think perhaps it's reached its limit, and we need now to think of a radically different way of looking at the asylum, and to, if you like, to rebalance the power between the global North and the global South. And I think that is, to a large extent, a function of researchers, of refugee scholarship, as well as refugee practice.
Yeah, I'll give other people a chance, Anisa, but I just wanted to say I am convinced that especially from the colonial perspective, that the human rights lens, as you put it, that's problematic. And then also the problem with the 51 Convention is that it has no place at all for climate migration at this point. And we definitely are going to need, we need that new framework now. Thank you very much.
Thank you. And Patricia, it's interesting that you bring that up. And part of the impetus for this discussion is, Jasmine and I co-authored 2 cases for the OHCHR, and arguing that you have to expand the notion of human rights and include a colonial framework, and to include that, possibly as reparations, even though that hasn't had legs in a while, but just to start that conversation about responsibility.
I thought the idea of asylum as a form of reparation is extremely interesting. I thought that was a very interesting approach.
Yeah, we lost Jasmine. She's in Lebanon and she's without electricity. So I had wanted to ask her a question about just kind of root causes. She's working within the regions of the Middle East, North Africa, and Sub-Saharan Africa, and how these laws are affecting those populations. But hopefully she might join up again. But I'm going to share my screen once again to play Sara's response to that question.
So I think this question of where we place hope or locate the potential for social change is really important, and draws our attention to the multifaceted practices of resistance to exclusionary and violent border regimes in our present moment. So while the Australian context is certainly bleak, I do draw significant hope from the sustained and vocal resistance of refugees and asylum seekers themselves, and the capacity of that resistance to force change, sometimes small, other times more wide-reaching within asylum border regimes. Some refugee advocates in the Australian context are, of course, internationally renowned and known for their work. So most notably the work of Behrouz Boochani, the award-winning Kurdish journalist and writer, and Abdul Aziz Mohammed, a recognised human rights defender who has addressed the United Nations, has been really powerful and transformative, both in terms of organising refugee protest and resistance to Australian offshore detention on Manus Island, but also in theorising and drawing attention to Australia's brutal policies and practices. And I'm thinking here in particular, Behrouz Boochani's Manus prison theory that has since been taken up in academia and activism as well. But in addition, I also place hope in the everyday practices of resistance by and solidarity with refugees and asylum seekers. So to name just one example, I've recently been involved in supporting the advocacy of Iranian and Afghan refugee women and their families who've been in prolonged immigration detention, first on Nauru and then later in Australia. And they've made really brave and hopefully impactful interventions into the public narrative of offshore detention and the legal limbo they now find themselves in Australia through speaking with trusted journalists who amplify their struggles and voices, or through initiating legal action to challenge their incarceration. In addition, as a legal scholar, I do see the power of strategic litigation in the Australian context, as well as the crucial work of refugee casework lawyers in fighting for the rights and liberties of their clients. Strategic litigation, of course, is a double-edged sword. So in the last decade, there have been some significant court losses, most notably in a 2015 case where plaintiffs for a refugee client sought to block her transfer to offshore detention from Australia by arguing that her detention on Nauru was not authorised by Australian law. But the Australian High Court disagreed and instead held that refugees detained on Nauru were being detained under Nauruan law by the Nauruan government and not the Australian government, even though the Australian government funded and operated the detention centres. That said, there have been some really important legal victories in this time as well. And significantly since 2019, there's been a line of Australian cases that have compelled the Australian government to transfer critically ill refugees from offshore detention to Australia for the purposes of receiving life-saving medical treatment. And these cases have started to recognise that Australia may owe a duty of care to refugees and asylum seekers in offshore detention, and that Australian courts do have jurisdiction to make binding orders against the Australian government in relation to their treatment. And while this might not sound like much, I think in the face of an increasingly brutal and militarised border regime and successive Australian governments who willfully refuse to take responsibility for the harmful effects of offshore detention, I do think that it's been legally significant in undermining the viability and operation of offshore detention itself, but of course has also had life-saving implications for refugees who have been transferred to Australia as a result of such legal action. So to conclude, in terms of human rights-based solutions that I was asked to comment on for this contribution, I think in the Australian context, there are some sort of very concrete changes that need to happen in order to provide people with meaningful access to asylum. I'll limit myself to naming three. So first, perhaps most obviously, we do need to abolish the Australian government's power to keep refugees in mandatory indefinite closed immigration detention in Australia without being subject to any kind of bail process or judicial review, in favour instead of supported accommodation in the Australian community. And we do need to repeal the really harmful law and policy of offshore detention that has allowed the Australian government to forcibly transfer refugees to third countries like Nauru and PNG. Second, we need to make sure that Australian law actually recognises and enables asylum seekers to enjoy the right to asylum and to apply for protection in meaningful ways. Because as I mentioned, Australian law currently bars a person who has arrived unauthorised by boat from applying for asylum in Australia unless the Minister personally permits them to do so. And this, of course, gives the Minister a huge amount of power over the lives of refugees and can resign refugees to a kind of a state of legal limbo. And third, I think we need to provide people with pathways to permanency instead of only 3 to 5 year temporary protection visas. But of course, more fundamentally, I think these legal reforms really need to be situated in a larger sort of anti-racist politics or social movements that are First Nation led and that recognise the need to dismantle the violence, militarisation and securitization of the Australian settler colonial border, to challenge these border logics in their multifaceted manifestations, and indeed to work to decolonise the nation or the place that's currently known as Australia more generally in order to create more just futures. So I'll leave it there, and I look forward to hearing the recording of the contributions of the other panelists and the ensuing discussion at a later stage. And I do invite anyone with questions or comments to email me if you wish to do so. So thank you again, and I look forward to the subsequent discussion.
So we have a follow-up question to what you were talking about, Patricia, and also kind of follow up for me in the sense of what you said, lawlessness, which is to me is very concerning. Looking at even just within the context of what happened in 2015 with this kind of nation states and international community, just inability to transfer refugees from one location to another, where they had to go by extra legal means. And it's like this growing sense of lawlessness that you identified. And we have a question.
Yeah. To respond now.
Oh, did you read it? I don't know if Linda would like to read it out,
yeah.
or okay.
Please read it. Yeah.
Okay, I'll go ahead and read it if Linda doesn't want to. So Linda's asking, in trying to replace human rights, is it opening that door? Might we open the possibility of losing what we already have? There might be a risky scenario where the global south would not have enough power to introduce their perspectives, and the global north might use the opportunity to make an uglier version of current human rights.
Thank you. First of all, it's a slightly indirect way of answering the question, but I just wanted to acknowledge some of the points that Sarah made in her presentation, which I think I haven't emphasized enough. And I think it also touches on the lawlessness question, because I really do think she's absolutely right to emphasize the agency of the refugees themselves. In fact, it's simply, that's why we have still a system of asylum, but also to emphasize the changes, the challenges that come either through a full hearing or judicial review or whatever, that I think does produce some important gains, and those kinds of interventions certainly need to continue. And of course, it becomes increasingly difficult for migrants to challenge their position because of difficulties in accessing representation and legal aid and so on. But I think it really is important to emphasize that. On the question about human rights in a different paradigm, certainly not suggesting that we should abandon what we already have in terms of human rights. And I think I did acknowledge in my introduction that in terms of interpreting the convention in different situations, I think there is still a lot to be done within that paradigm. Bill mentioned the question of climate refugees. I think there are quite a few problems with addressing displacement in relation to climate change within the Refugee Convention, even with a creative human rights approach, partly because I think it would be very difficult to think about persecution in where there's a non-human agent. So I think there might be a problem with that. But nevertheless, I think that I suspect that there may be questions around transgender rights, for example, that might be addressed within the convention. But so there's still scope for that. In terms of the the core of the question, though, which is, I understand entirely, which is to be realistic about the power of the global north as opposed to the global south. And I entirely accept that. And that's why I wanted to acknowledge that this isn't a question of simply saying, should the OAU convention should be the dominant way of looking at asylum. I mean, that there is an argument for that, because I think most analysts accept that the African Convention defines much more accurately the conditions of contemporary refugees and so on. So there is an argument for it, but I appreciate that that is not going to happen. I'm thinking of something that on the surface may appear more modest, but I think could be quite significant. So, for example, I mentioned the question around the paucity of decision making, just the basic day-to-day routine decision making in the UK Home Office. And these are decisions made by caseworkers who probably don't have a particular political position, are slightly hard pressed, and they're dealing with the information they have. And one of the problems, particularly about the knowledge of the conditions in a particular country, is that they can only use English sources because no one's going to pay for the translation. So there's nothing to suggest that if with a greater range of information, with some sources that might contradict the dominant source, that there might not be a better outcome. So something like that. But the question is, why is it that all of our practices almost in the global north, certainly in the UK, is largely determined by the fact that English is the dominant mode still, in which many of these sources are produced. So I think it does require a decolonial effort from the global north. And I'm an academic. I'm speaking from that limited perspective that even my practice should be much more attentive to other sources of analysis, as well as in terms of policy. And if that means that I might have to invest a bit more in getting sources translated and so on, so that I have a better perspective, then I think that should be done. So it was really the point that I made earlier in my in the presentation about how little real information there is available to scholars and practitioners in the global north about how either the Latin American Convention or the African Convention operates. I mean, it's just not there to any any accessible degree. So I think those kinds of changes could give a different perspective on how to deal with asylum seekers. And just one concrete example, is that the question of responsibility sharing, or as it used to be called, burden sharing, is obviously high on the agenda in northern states. And it's quite interesting that in the convention, the 1951 Refugee Convention, the need to develop policies around sharing costs of refugees is implicit in it, and I think it's in the preamble. But actually, under the OAU Convention, it is part of the substantive requirement. So already, at a much earlier point in the development of a regime, the question of the need to cooperate around the sharing of the costs of refugees was something that was already in the psyche. And I think it's those kinds of things that perhaps we could benefit in ways that would change the dynamic without, as I understand, entirely take Linda's point, without putting the burden already on states that are already carrying the greater share of asylum seekers and refugees. Thank you.
It's interesting that you thank you for that clarification. It's interesting you bring up the individual caseworkers and the non-presence of what's happening in a particular state and not being able to access the language. And Hassan al-Kunar, who was trapped in the Malaysian airport, he was a Syrian refugee for, I think, a year or so. He recently wrote a book, Man at the Airport. And it essentially talks about how he had to navigate these multiple systems in different countries and working with just kind of middle management bureaucrats and their interpretation of what the law might be or not be or policy. And I highly recommend the book. Again, his name is Hassan al-Kunar, and it's Man at the Airport. If you also look at the link for the GRN YouTube page, we did do a book talk with him. So that's also there. And you also bring up just kind of this disconnect between practice and research and policy. Tomorrow, that's the conversation I'll be having with another panel, looking at researchers, activists, community activists, as well as how can they influence policy? You know, as Professor Hing had mentioned, just putting the pressure on decision makers to look at these issues. And also, you know, when we think about law, we think that we put it into perspective that we forget that law is created by people who have different perspectives. And even if you look at the medical field, at one time it was acceptable to not give someone who was African American painkillers because obviously they could take more pain, they could tolerate more pain. And that has been disproven. And you know, if we look at if the medical practice is coming to approaching patients from a colonial mindset, what about the law? Where the law is, you know, such an important aspect of how a society is arranged and managed, and how who is accepted, who is included, and who is excluded. And Linda has another question. What role might academia play in contributing to introducing this colonial perspective to expand on the current human rights?
I think an incredibly crucial role, because I mean, it's still the case that the primary, I suppose the primary function of the academy is to be receptive to ideas, to different perspectives, and so on. I think universities, in particular, compared to, you know, to some small practitioners, for example, who deal with asylum, obviously often are not the most well off in terms of the resources, but I think probably would have greater resources in order to support translation, and sometimes it's possible to get grants in order to support the costs of translating materials and so on. So absolutely, I think a very, I mean, it's really just about, you know, to put it really simply, that it's about what we're reading and being able to make it possible to engage specifically in the context of the Refugee Convention, to be able to engage with the case law that's emerging from the OAE, so that we can begin to see, are there different principles, different approaches that might be relevant. So yeah, I think it quite a great deal. And I think that it is happening. I think that it is there is some appetite for the challenge, I think.
And one of the main premises of MINS is looking at that connection between how academia can reshape research to contribute positively to the lives of refugees. And also the Global Research Network, we work across disciplines to focus on these issues. And just yesterday, I was having a conversation with a professor in India, and they're going to have a conference on decolonizing the social sciences. It's a very, very key thing to start to look at, because the social sciences were essentially a tool of colonization in the science, particularly anthropology, sociology, economics, all contributed to kind of the domination, justification of these domination. And again, the panel that we're going to have tomorrow really focuses and hones in on looking at qualitative and quantitative approaches. Typically, policy is driven by economists, just very quantitative numbers. And when you bring in ideas that are more qualitative to explain and expand on those numbers and explain why that's there, we're going to have the pleasure of having Colette Can and Eric de Molinera, authors of the Activist Academic, who are going to talk to us about an alternative, not even an alternative, but a different approach to impact, a different framework for impact. So that's, there's just multiple ways, and that's what the vision for the GRN think tank programs are, which Patricia, she's very active with the think tank programs and also is a board member of the GRN. So these are things that we are continually striving to tease out, figure out how we can do this as a global academic community who are sincere and concerned about bringing the concept of colonization to multiple disciplines as a lens from a practical perspective.
Yeah, I mean, I am so I'm a legal academic, so I think generally, I'm obviously most familiar with the law schools, but I think it's important to say that, one of the things that law schools specifically can and are doing increasingly is using their students to provide at least basic support, and depending on how advanced the student is, probably quite substantial legal support for asylum seekers or others who are facing the immigration state. And I think that kind of intervention, especially where legal aid and other forms of support are not available, is invaluable. And I think that, those kinds of developments, I think, are important as well. So it's again emphasizing Sarah's point that often, still in this world, change often comes about because of one or two people going to court and, being able to take that case right up to the Supreme Court, and then there could be quite a substantial amount of change. And I think, that being able to support that activity is something that I think universities can do.
Well, we have just 1 minute left. I want to thank all of the panelists for joining us today, and invite all of you to go ahead and read their bios and connect to them on various social media platforms that are in the conference flyer. And this was a wonderful conversation, and I hope you enjoyed it as much as I do, and I hope we can continue this conversation. Please follow us on Facebook or Twitter, the MIMS USFCA, or the Global Research Network, GRN, on the various platforms, Facebook, Instagram, LinkedIn, and our website at www.grn.global. And with that, I will close out for today and thank all of you, and look forward to your participation in the conference.
Thank you. I enjoyed it. Yeah.